Every single year, immigration law firms are leaving 7 figures on the table. And not because they don't have clients, but because they don't have the infrastructure to handle post-removal cases. Between fiscal years 2024 and 2025, immigration judges issued over 780,000 removal orders, and roughly 2/3 of those orders were in absentia. That's not a niche, that's a pipeline. And most firms shut it down at intake without ever realizing what they just walked away from. In this video, I'm going to show you where that money actually disappears and the one structural decision that determines whether a firm can capture post-removal work or keeps bleeding it quietly year after year. Here's how this actually plays out inside most firms. Someone calls with a removal order. Not a new case, not a clean slate, a loss. The intake conversation slows down immediately. The tone changes. Someone says, "This might be reopenable, but let me see if we even have the capacity for this." And that's the moment the case dies. Not because anyone analyzed the record, not because the law was bad, but because there's no system behind the question. No framework, no way to tell quickly and confidently whether this case is a hard no or a case that deserves real analysis. So the firm does the safest thing it can do without realizing it. It says no. I see this problem so clearly because I work almost exclusively on post-removal cases, motions to reopen and BIA appeals, where the question isn't, can we win? It's, should this case have been lost in the first place? That means my job starts where most firms stop. I review records, I map timelines, I look for procedural fractures, such as notice defects, ineffective assistance, deadline traps, and I build reopening theories that actually hold up. And when you look at enough losing cases side by side, patterns become impossible to ignore. When firms struggle with motions to reopen, they usually think it's a legal problem. Well, it's not. It's an infrastructure problem most of the times. And it shows up in 3 very specific ways. First, post-removal work requires a different skill set. Trial prep and post-removal litigation are not the same discipline. Trial work is about facts, declarations, country conditions, and testimony. Post-removal work is almost entirely procedural. You're not asking what happened, you're asking what went wrong in the process. That requires deep familiarity with UIR rules, BIA reopening standards, circuit law, and how notice, deadlines, and prior counsel errors actually operate. Most attorneys don't live in that world long enough to stay sharp in it. Second, the time investment doesn't scale. A serious motion to reopen takes real time. You have to pull the record, reconstruct the timeline, research the theory, and draft carefully, side-checking everything. And if you only do 1 or 2 of these a year, the economics don't work. You never build speed, you never build templates, you never build confidence. So the work always feels heavier than it should, and it never becomes repeatable. Third, you inherit someone else's loss. Post-removal cases come with baggage. You're stepping into a case that already failed, maybe because of bad facts, maybe because of bad lawyering, or maybe because of both. If the motion is denied, you're now the name on the denial. From a risk perspective, that makes firms hesitate, especially when there's no internal system to separate strong cases from dead ends early on. But here's the reality. The same reasons most firms avoid motions to reopen are the reasons they're so valuable. They're technical, they're high risk, they require specialization, which means fewer firms are willing to take them on. But here's the part firms consistently underestimate. When a motion to reopen is granted, at least 1 new case is born immediately. Not maybe, not sometimes. Every reopened case requires follow-up relief, whether that's cancellation of removal, adjustment of status, asylum, VAWA, or a waiver. And each one of those is a new retainer. That new contract is almost always larger than the motion itself, because it involves full merits work. And this is not theory. That's how the practice actually works. In the last year alone, I drafted over 40 motions to reopen that were granted. Those grants directly generated over $350,000 in new revenue for the firm. Not because we were lucky, but because reopening was treated as a repeatable system. Not a favor, not a gamble, and not something we only did when we had spare time. Let me give you a more common example of how reopenable cases actually get missed, even by competent attorneys. And again, I'm not going to explain basic concepts. You already know them. A client receives an NTA. It includes a time and date for the initial hearing. Then the court adjusts its calendar and it issues a subsequent notice of hearing with a new date. The client never appears for the hearing. The immigration judge enters an in absentia removal order. When a new attorney reviews the case later, they see the removal order and assume the problem is simple. The client missed court. That assumption is where mistakes get made. The real questions are never just, was there a hearing? The real questions are, was the hearing notice actually served? Was it sent to the correct address? Did the respondent comply with address update requirements? Because if the notice of hearing was never properly delivered or was sent to an address that the respondent was no longer required to use, you may have a viable notice-based rescission argument. And that's how cases are missed. Not because attorneys don't understand the law, but because they don't have a system that forces them to trace the NTA, the subsequent hearing notice, address history, and the basis for the in absentia order. If your intake process doesn't require that analysis every single time, you will misclassify reopenable cases as dead ends. I've drafted dozens of successful motions to reopen on this exact issue, and most of them were initially written off for the same reason: no structure. At this point, the difference between firms that capture post-removal work and firms that don't comes down to one decision. Do you treat motions to reopen as exceptions, or do you treat them as a pipeline? Most firms treat them as exceptions. A strange case, a risky case, something you only take when you have time, which is almost never. That approach guarantees inconsistency. It guarantees hesitation at intake, and it guarantees missed cases. Firms that do this well make a different choice. They don't decide whether to take motions to reopen on a gut instinct. They decide how every post-removal case gets evaluated. That means every case goes through the same intake triage. Every record gets a timeline map. Every case is sorted into a specific reopening theory, and only then does drafting begin. And the moment you build that system, one thing becomes obvious. Intake, not drafting, is the real bottleneck. That's why I built what I call the motion to reopen decision tree. It's not a checklist, it's not a questionnaire, it's a logic map. In a single intake conversation, it forces you to answer the only questions that actually matter. Are we talking about rescission or reopening? Is the theory notice an effective assistance or a statutory exception? Are the deadlines fatal or is tolling legally available? And most importantly, is there a coherent theory that can actually survive scrutiny? If the answer is no, you say no quickly and cleanly. If the answer is yes, you know exactly why and what kind of motion you're dealing with before you draft a single page. This decision tree is part of a motion to reopen playbook I'm releasing soon, built from the same framework I've used to evaluate and draft hundreds of winning motions to reopen. And for people watching this video, I'm making the decision tree available as a standalone resource absolutely free. Once firms accept that post-removal work needs structure, they usually land in one of three models. Some build internal capacity, a senior paralegal or legal writer dedicated to post-removal litigation. Attorneys review and sign. Some attorneys choose to specialize themselves, investing the time to stay current on reopening law and building their own systems. Others use collaborative models, contracting legal writers or specialized partners who handle the heavy lifting while the firm manages the client relationship. That's where I often come in. All three models can work. One model consistently fails, doing this ad hoc. Taking a case when you feel good about it, skipping cases when you're busy, letting intake rely on instinct instead of structure. That's how strong cases get declined and weak motions get filed. If you are serious about post-removal work, not occasionally, not reactively, this is the lane I'm going to keep breaking down. The next videos will go deeper into losada traps that kill otherwise strong motions, in absentia standards firms still misunderstand, deadline method actually matters, and how to choose the right reopening theory before you draft anything. And if you want the motion to reopen decision tree I mentioned, I'll explain how to get it in the description. And if you are facing a post-removal case and want a second opinion on whether it's actually reopenable, my email is there as well. As always, keep your steps steady and your purpose clear. I'll see you in the next one.